Hello. Mandatory mediation and arbitration, in principle, became an option this spring, but all this time the government regulation was awaited, because without that regulation it was not yet applicable, neither the mediation nor the arbitration in the small claims court, in the Cour de Petite Créance. And finally, the regulation is available as of November 1st, 2023, and it shows that the rules are gradually becoming applicable. Why gradually? Because at this point the regulation only applies to certain judicial districts, notably to exclusion of the judicial district of Montreal, as you can see, though Laval and Longueuil are there in the list. So probably it's because of this famous or infamous overload in the Montreal courthouse, maybe for some other reasons, but still for now it is not applicable in Montreal, so Montreal still is waiting for it. There are limits, as you can see, for both mediation and arbitration, particularly when it comes to the situation when parties or one of the parties is a victim of conjugal violence or sexual violence. We are talking about civil cases, of course, not about criminal cases. When the parties requested that the judge might render a judgment simply just in the view of the record, without meeting parties, so there is no need to proceed with any kind of mediation or arbitration in this situation. Also, when somewhere in the application there is something about constitutional validity or otherwise validity of the laws of Canada or Quebec, and if fundamental rights were in question or are in question, then again mediation is not available in these cases, and neither is arbitration. Also, when it comes to arbitration, Article 2639 of the Civil Code of Quebec prohibits arbitration or makes it unavailable in the matters of capacity of persons and family matters, or the matters of public order. So there are still a lot of limitations, but otherwise now in those judicial districts, again, mediation and arbitration, mandatory mediation and quasi-mandatory arbitration is available. Also, there will be no mandatory mediation if a party, one of the parties, is under order that prohibits basically that party to come in presence in the view of the other party. Sometimes, if it's like technically impossible, at least in practical, to go through with the mediation at a distance, like via video conference normally, and it's also impossible or impractical that the party comes in person, so then again the mandatory mediation might be not available, so the party might be just exempt from it. It's possible that there was also already a mediation session for the parties. Maybe it didn't work, but still there was one already. And in such a case, particularly when there is a court order prohibiting like meeting in person, then the file again is back to the court. if mediation comes to an end without a positive result, then this quasi-mandatory arbitration comes as a next step. Why it's quasi-mandatory? Because there is an option to opt out of it, and for that, a party which does not want to go for arbitration has 30 days. And if within 30 days that party does not inform the court office that they want to be out, then arbitration becomes mandatory, and if the party fails to attend, then the judgment by default might be rendered. The same rule is reflected in that part of the regulation which talks of the arbitration itself. So different article number, but the same rule, 30 days. And it also adds that even if at a certain point the parties decided not to go, or one of the parties decided not to go with arbitration, they can change their mind and they can still go with arbitration. So if you're interested, there are more details in the Règlement sur la médiation et l'arbitrage, regulation on mediation and arbitration in small claims court, as of November 1st, 2023. And again, it all has like practical sense in these judicial districts for now. We are waiting that gradually it will become available in other judicial districts. Thank you and have a nice day.